Alberta's unique personal guarantee arrangements. Attaining bank loans and debt financing in the province of Alberta is subject to distinctive financing and guarantee arrangements that arise from the Guarantees Acknowledgment Act and the specific legal requirements imposed therefrom. With most banks and financial institutions requiring personal guarantees for corporate debt financing, these legislative requirements need particular attention and require the engagement of legal counsel. With most personal guarantees in Alberta requiring the attainment of a Guarantees Acknowledgment Act certificate pursuant to the statutory requirements of the Guarantees Acknowledgment Act. The Guarantees Acknowledgment Act is a provincial legislation exclusive to the province of Alberta that is designed to protect individuals who provide personal guarantees for loans or other financial obligations. The intent of the legislation is to ensure that a guarantor fully understands the significant legal consequences providing a personal guarantee and being properly informed when signing such an agreement. As such, to properly understand the Guarantees Acknowledgment Act, it is critical to understand the legal concept of a personal guarantee and why the Alberta legislature sought to protect individuals who provide personal guarantees for loans or other financial obligations. When a business corporation, the primary debtor, borrows money or takes on an obligation, a lender or other party may require the business owners and or another individual, the guarantors, to promise to repay the debt or fulfill the obligation if the primary debtor defaults. This makes the guarantor personally liable for the debt, often extending to their personal assets. For corporate business, a personal guarantee is frequently required for a business loan, a commercial real estate lease, an equipment lease, or a supply arrangement. The core purpose of the Guarantees Acknowledgment Act is to prevent fraud and protect individuals from unknowingly taking on substantial liabilities. It sets out specific procedural requirements that must be met for a personal guarantee to be legally enforceable in Alberta. These requirements include 1. Appearance before a lawyer. The individual giving the guarantee, the guarantor, must appear before a lawyer. 2. Lawyer's examination. The lawyer must examine the guarantor to ensure they are aware of the contents of the guarantee and fully understand its effect and implications. This means the lawyer has a duty to explain the risks, including the potential loss of personal assets. 3. Signed certificate. If the lawyer is satisfied that the guarantor understands, they must then issue a Guarantees Acknowledgment Act certificate. This certificate must be signed by both the lawyer and the guarantor. Crucially, if these steps are not strictly followed, the guarantee has no legal effect in Alberta. This can render a guarantee completely unenforceable, even if the guarantor intended to provide it. The Guarantees Acknowledgment Act is highly important for several reasons. Guarantor protection. Its primary importance lies in safeguarding individuals, particularly those who might lack extensive legal or financial experience. It acts as a consumer protection measure, ensuring that a serious financial commitment like a personal guarantee is not entered into lightly or without full comprehension. Prevents unfair surprise. Without the Guarantee Acknowledgment Act, individuals could potentially be held liable for debts they didn't fully grasp, leading to severe financial distress. The Act forces a moment of reflection with legal guidance. Unique in Canada. Alberta's Guarantee Acknowledgment Act is unique among Canadian provinces. While other provinces have common law principles related to guarantees, Alberta has this specific statutory requirement, making it particularly important for anyone dealing with guarantees in this province. Enforceability for lenders. While it places a burden on lenders or those receiving the guarantee to ensure compliance, it also provides clarity. If the Guarantees Acknowledgment Act requirements are met, the lender has a strong basis for enforcing the guarantee. Failure to comply, however, means the guarantee is essentially worthless in Alberta courts. Due diligence requirement. For lenders and legal professionals, the Guarantees Acknowledgment Act imposes a strict due diligence requirement. They must ensure that proper process is followed, including the lawyer's examination and the issuance of the certificate, to ensure the enforceability of the guarantee. In essence, the Guarantees Acknowledgment Act serves as a critical legal safeguard in Alberta to ensure that individuals providing personal guarantees do so with their eyes wide open, fully aware of the potential far-reaching financial consequences. Important note for guarantors. For anyone considering becoming a guarantor, it's crucial to understand the significant financial responsibility and risks involved. They are legally obligated to fulfill the terms if the primary party defaults, and this can have serious consequences for their own financial and credit history. Consulting with legal and financial professionals before signing a guarantee agreement is highly recommended. For more information about our law firm's legal practice, including legal work regarding bank loans, debt financing, and the Guarantees Acknowledgment Act, visit our website or contact our law firm to schedule a confidential consultation. Thank you.